Hello, Namaskar, Sat Shri Akal, and welcome to another episode of our unique initiative, What Law Says. I am Advocate Kamar Chima from Rajan Kamar Legal Advisors India LLP and your host for today. What Law Says is a platform where we take up the queries of our NRI clients and try to answer them based on our experience as well as the prevalent law of the country. In today's episode of What Law Says, we will answer the query of one of our clients from New Zealand. She has raised certain queries and due to her personal and privacy reasons, we will not name her, but nevertheless, we will answer her queries. Let us now see what she has to say. Well, she says, my marriage was solemnized in the year 2017. At the time of marriage, my husband had portrayed to me that he has done his B.Tech from a reputed university in Punjab. Since he was the son of a close friend, we did not verify his educational qualifications. Now it has come to my knowledge that he had made false claims regarding his educational qualifications. After marriage, I had come to New Zealand and since then we have not been staying together. Now I do not want to remain in this marriage and want to file for a divorce. I have discussed the same with my family and also my husband, and we are willing to file a mutual divorce. I do not want to come to India. Can I obtain a divorce without coming to India? So the question is, can an NRI file for divorce without being present in India? Let us now see what the law says as far as this question is concerned. A similar situation arose in the case of one Amrinder Singh, which was decided by the Honorable Punjab and Haryana High Court. I will read the relevant excerpts from the judgment as of now. In this case, void the impugned order, the District Judge of Family Court in Faridabad had directed the petitioner husband to be present at the time of recording second motion statement in mutual consent divorce filed under section 13B of Hindu Marriage Act. The fact was that the petitioner husband was residing in Australia and was unable to come to India. The petition under section 13B HMA for dissolution of marriage by way of mutual consent was filed by petitioner husband through his uncle in his capacity as his general power of attorney holder. The statements of both the parties were recorded by the trial court, but the trial court directed the special power of attorney holder to produce the husband petitioner in person at the time of recording of second motion statement. The Honorable High Court of Punjab and Haryana, after going through the contentions of both the parties and the various judgments of other high courts on the subject, observed that since the dispute between the parties has been settled with certain terms and conditions, and since the respondent wife also has no objection in the case, the statement of the power of attorney holder of the petitioner husband is recorded in second motion. Hence, the presence of the petitioner husband is not mandatory at the time of recording of the second motion as per the provisions of the Hindu Marriage Act. Thus, the law is absolutely clear that as far as divorce under the provisions of section 13B, that is mutual divorce, is concerned, the same can be filed as well as contested by either of the parties through his power of attorney holder, provided the other person has no objections to the same. I hope I have been able to answer this query of our NRI client. I hope I have been able to satisfy as far as this query is concerned. This is a platform where we answer the queries of our NRI clients. And if you have any query whatsoever, please feel free to contact us or write to us and we will try to answer the same based on our experience as well as on what the provisions of law are pertaining to that particular query. See you soon with another episode of What Law Says. Till then, do whatever you want to do, but try and avoid any sort of litigation. And if any litigation is forced upon you, then you know whom to call. Take care and have a good day.